Joining us on making
Well, welcome everybody. We're going to go ahead and get started. We're very excited to have one of our alums, excuse me, Dee Pierce.
Just answer
Have your
question,
attention.
sorry.
We are very excited to have an alum of the law school, Marco Brown, with us today. I'm really excited to hear what he has to say. When he said that he had this CLE that he's done before about your number one job as an attorney is getting paid, I knew that we were going to have a lot of people interested. Today we have a number of people from the legal community with us. Later we're going to show this. We're recording it today, so be careful what you say. But we're going to record this because a lot of our third-year students are very interested in learning from what he has learned and all the experience that he has as a solo practitioner and now as the owner of a law group. Is it the Brown
Law.
Just Brown
You
Law.
can call it whatever you want.
Okay, well, Marco, in addition to many other attributes, was named as the Utah Family Law Lawyer of the Year. He has not been out that long, like I said, a 2007 grad, and I'm just really excited to have him here. So please join me in welcoming him, and I'll let him take it away.
Thanks everybody for coming out. Marty Gardner was in here before, so there's heads all over the place. So let me tell you a little bit about who I am and how I got to this place and this presentation. So I graduated here in 2007, and I just need to take a second and thank the law school for this. I loved my time here. I thought I had really excellent professors and colleagues in the form of other law students, and we just loved it out here. We got our first son Elliot out here. It was just a great time to be here, and I really appreciate the school for all they did for us. After I left here, I went to the 3rd District in Iowa, clerked for a year, and then went to New Mexico and worked for an insurance defense firm. It was about, I think it was a 50 or 60 guy shop, the second largest law firm in New Mexico, and it was by far the worst job I've ever had in my entire life. It was an insurance defense firm, and I can't think of anything more boring other than tax to do with your legal career than insurance defense. So I made it for approximately 18 months there. The last 3 months I was there, I didn't smile. My wife can attest to that. She's over there with their 5-month-old, but it was a bad time. So when my wife came to me and said, I want to start a doctorate program at the University of Utah. We graduated from BYU, so we knew the area. I thought, okay, this is a great chance to get out of my job, so we did, and we moved up there. That's 2010, and I'm not a very bright individual, and I thought, hey, this would be a great time to start a law firm. 2010 wasn't a great time to do anything. It was a bad time to pump gas back then. I mean, 2010 is when literally the large firms in New York and LA and Chicago were just closing down. They were laying off, and if they weren't closing down, they were laying off 200-300 attorneys. It's bad. So that's when I started, and I just had to bust my hump. I had no network, I had no clients, I had no nothing. I had to figure it out, and I made lots and lots of mistakes along the way, a ton of them. And kind of fast forward through that to about 5 years later, I found my groove a little bit. 5 years later was when I won the Divorce Attorney of the Year in Utah, so I figured out a niche, right? I was good at it. I got recognized by my peers for it, and I don't put a lot of stock in awards, but that was the one award in my life that I've been really proud of, was winning that. But even at that point, there were still lots and lots of problems with what I was doing. There were a lot of systemic problems in the law firm. And then there were personal problems in the sense that I was doing a ton of work and not getting paid for it, and that has all sorts of bad effects. So I was stressed a lot. I was going, but I was stressed a lot. I was working a ton. I got myself fat, you know, when you're stressed, when you sit in a chair for 13 hours a day, you kind of get fat, like that's what happened to me. And that's a big thing for me. I've always tried to stay at least relatively fit, and that was not my state of being at that point. I remember I would get in the shower in the mornings. I love showers. So I'd get about 5 minutes of reprieve in the shower when I didn't think about a case. And then after 5 minutes, I would start thinking about cases. And my heart would start to palpitate, and my chest would start to constrict. I can feel it even now as I'm talking to you, that feeling. And it was horrible. I knew in those moments that I was going to die when I was about 60 or 65 of a heart attack if I stayed on that path, if I kept doing what I was doing. And I didn't really want to die when I was 60 or 65. I liked my kids, I liked my wife, I didn't really want to end it like that. So I really did some soul searching and trying to figure out what I could change that would bring about other kind of, you know, kind of trickling down systemic changes. What's the big thing I could change that will improve a whole bunch of different things? And I decided to get paid 100% for what I do and see what else kind of happened from there. So that is the impetus for this CLE, is the kind of how I did that. And we don't get paid, just to be totally upfront, we don't get paid 100%, we get paid about 98% for what we do, which is still pretty dang good. When you look at most law firms, if they go 75%, 85%, I mean, there are very, very large law firms in Salt Lake where we live, 85% is what they shoot for. I think that sucks, man. You should be shooting for 100, but you know they accept that. But 75% isn't bad. But I thought, all right, let's do 100. There's one law firm in Salt Lake. The managing attorney told me if we get 50%, then I'm satisfied. I'm like, you work 2 hours and you paid 1 hour and you're satisfied with yourself? Like, it's cheating your people. But anyway, they're not a very good law firm. So, okay. Let's get into this. I want to talk about the extent. First, I want to talk about the extent of the problem here, and it's a big problem. So, anybody use Clio in the room as a case management system, firm management system? Clio is it's kind of like Rocket Matter, or there are a whole bunch of different ones. Clio is the best one. It's in the cloud. I like it. It's what we use, but it's the largest kind of case and firm management system that you can buy. They have tens of thousands of American lawyers who are clients. So what they do every year is they send out what's called the Clio Trends Report. What they do is they take the data, the actual user data they get from attorneys, they aggregate it and they anonymize it, and they pick out all these data points to kind of let you know the state of the American attorney. And it's not particularly good. In 2016, the Trends Report, these were some of the statistics. The average attorney worked 8 hours per day, billed 4 hours per day, and collected 1.4 hours per day. Okay. What is that, 22% is a realization rate, I think. That's good. In 2018, it got slightly better. It was 1.6 hours per day that was actually collected out of 4 hours per day. Okay. Now, you may be thinking, this is nuts, how could that be? This is actual user data. So this isn't survey data. Survey data kind of sucks in general, in the sense that survey data is that stuff when they ask you how often you work out, and you say 5 times a week when you actually go out and walk for like 20 minutes on Sunday morning or something. That's what survey data is. This is actual user data, so you can't lie about this stuff. So that's the Clio data. LegalZoom also took some data. Found that solos account for 56% of attorneys in America. Their average revenues per year, $78,000. That's top line, not bottom line, top line. And their profit, bottom line per year, $63,000. So the average American attorney is a solo making approximately $63,000. And they bill 398 hours per year. It's just not good. Like this is a serious problem, and that's why I'm here today. And then I want to talk to you about the time to get paid. This is some really interesting data as well. This comes from Clio, again, user data, not survey data. The average lawyer, from the day they do something on a case, the day they work on something, to the day they send out the bill for that thing they did, 87 days. Okay? 83 days from that date, the client pays the bill. That's 170 days from the time of work until the time of payment. Now, all the data shows us that once you get past about 90 days on collections, your chance of actually getting paid goes down by, I don't have this, but I think it's somewhere at 80%. I mean, it just drops off dramatically once you get past 90 days. So we're gonna talk about that a little more. But again, average attorney doesn't bill the whole time, doesn't collect the whole time, and part of the problem is it takes them 170 days to pay. So let's talk about how we can keep this from happening. And there are I give 8 commandments here. And I was gonna ask, why don't you call them rules, commandments? This is a room of lawyers, and we're in a law school. So in law school, when we were told about rules, what we did was try to figure out how to get around, right? Like that's what lawyering is, that's what law school is. But a commandment is something given to you by a higher power. If you follow it, your life will be better. And I'm not saying I'm higher powered, I'm saying that this is what's worked, right? Like follow this stuff and your life will be better. I guarantee it. Okay. So the first commandment is change your mindset about money and about getting paid. Now, with all due respect to law professors, one of the first things I was taught in law school was that my number one job as a lawyer was to do good. I don't actually know what that means, but I was told that a lot in law school. And then after I graduated and I became an attorney, I was told by the bar the best possible thing I could do. And you guys have a different situation with the bar out here. You have a voluntary bar now, is that right? Instead of a mandatory one, which is great because they actually have to serve you a little bit instead of just trying to screw you. So that's good. but you're told, like in Utah, and I'm sure here too, that you're told the best thing you can do with your time is to do pro bono work, right? So like give away your stuff for free. So you're told by your law professors, who are the first people to teach you about lawyering, this, and then you're also told by the bar that the best thing you can do is kind of give away your time. Okay, that's complete crap. Don't do that. Love law professors, but they're kind of bureaucrats, right? They don't have to kill something and then take it home and cook it and eat it. That's what we have to do. So you got to change your mindset about these things. You need to realize that your number one job, your first job as an attorney is to get paid. And your second job as an attorney is to do exceptionally well for your client. Okay? This is the ethics of getting paid. And think about it like this, if it helps you. It's actually unethical to get paid less than 100% for what you do. Okay? And what I mean by that is, let's use an analogy. Let's imagine you're sitting in your office and you have $100 in your pocket, and your client comes up to you and takes that $100 out of your pocket and walks away. Your client has stolen money from you. And if you allow your client to steal money from you, you're being unethical, right? You're being unethical and allowing them to commit a crime against you. And that's exactly what you're doing when you allow your clients not to pay you. You have a contract. The contract says, I will do exceptional work for you and you will pay me. So when they don't do that, they're breaking the contract. It's unethical to do that. It's also conversely unethical for you to suck at your job as an attorney. So be excellent at your job. That's your duty. But their duty is to pay you. So you gotta change the mindset here. Okay, that's the first. The second is bill regularly. Okay, and if anyone has any questions along the way, just raise your hand and we'll talk about it. Bill regularly. This is one of the biggest problems in collecting. Gave you that data, 170-day turnaround time. I know an attorney in Salt Lake. She is a very good friend of mine. She's a divorce attorney, and she bills her clients every Monday morning. Every Monday morning. You know, she bills them on Friday, and then she collects on Monday. It's on a credit card. It just happens like that. That woman gets paid, man. She is amazing at it. I actually tried her system because I like to experiment with systems, see how they work. Did not work for me. My paralegal threatened to quit about a week into it. So that doesn't work. I bill once a month, and that works for us because of the way we have things set up. But she does it every week. The point is, find whatever works for you and go with it, but don't ever get beyond a month. Because the longer you go, the less likely you are to get paid. So imagine you haven't billed for 2 months or 3 months, and you build up, you build it up, and then you send out a large bill, and your client hasn't seen anything for 90 days, so they're not used to this, and then you have this huge bill. They're gonna get upset, right? And they're gonna call you, and they're gonna ask for a discount, and you're gonna feel guilty because you didn't send out the bill, so you're gonna give them a discount, which you should never do. Don't discount your time. It's your time. You did that work. You should bill for it. But you feel kind of obligated to do that, so you end up getting less money anyway. And the other thing about it is that if you have a situation where you're not getting paid and you haven't sent out a bill and you want to get out of the case for some reason, your client's a jerk or things just aren't going well, then you feel trapped if you haven't sent out that bill, right? You're 2.5 months in and you haven't sent out a bill, you just feel trapped in the case and you're less likely to get out when you know you should get out. So bill at least once per month. The third is don't chase money. Okay, let me tell you what I mean by this. Chasing money is taking cases that you don't normally take, doing things that you don't normally do, and working for people that you don't normally work with. We're doing favors for people. These are all examples of chasing money, and let me concretize this a little bit. So I'm just gonna personalize it. So you're a divorce attorney and you're meeting with somebody, you're meeting with your client who just got in a car wreck. And it's pretty clear, the causation, all that kind of stuff is pretty clear. And you want to take that case, right? Because you see dollar signs. You're like, I can figure out personal injury. That's not that hard. In fact, one of the reasons I'm an attorney is because when my wife and I lived in Vegas, I saw a guy on television, his name's Glenn Lerner. I don't know if anyone's ever been to Vegas and seen it. Okay. So Glenn Lerner is this little guy. He's about 5'6" or 7, I think. Lifts a lot of weights, so kind of a bigger guy. But he has this Boston accent and lives in Las Vegas. And this commercial was Glenn explaining to a Spanish audience the way the American court system worked. So you had this little guy from Boston with a Boston accent speaking Spanish to a whole bunch of to a Spanish audience. Sitting in front of a jury box. It was a crazy commercial. And I remember thinking to myself, and I turned to my wife and I said, man, if this guy can do this, I can certainly be an attorney, right? So you want to think, oh, hey, personal injury, it's just not really all that hard. I can do this. That's you chasing money. That's you seeing dollar signs and just going after it, right? Because that's not what you do. Don't do that sort of stuff. That doesn't lead to good things. It leads to you waking up at 3 o'clock in the morning thinking, did I do this, this, and this? Do I even know what I'm doing in this case? Why am I doing this? All of these things come up in your mind. Just don't chase money, right? The other great example is favors you do for other attorneys, or you charge people in your congregation, where you take some low-level criminal case, right? You have no idea what criminal work is. Like, how hard could this be? You figure out real quick that a DUI is actually really difficult, right? So, those sorts of things. But you take those because you see, someone's getting paid $5,000 for it, and you see money, and you want to do that. Just don't chase money. It's never worth it. Saying no is the most freeing thing you can do as a human being, really, and it's certainly the most freeing thing you can do as an attorney. So, don't chase money. Oh, and don't discount your rate. If you ever get to the point, if someone asks you to discount your rate when you meet with them, or in the middle of a case, or something like that, or you feel guilty and you want to discount your rate, you're chasing money because you're trying to keep that person in. Get that person in or keep that person on. Don't ever do that. Just, your prices are your prices. Do exceptional work and get paid for what you do. The next one, number 4, is always have money in trust. I call this the banana stand commandment. If anyone ever watched Arrested Development? Anybody in the room? Okay, right. You'll get this. And I was explaining this for the people who haven't watched Arrested Development, but it's a great show. Go watch it on Netflix. But there's this kind of running joke in the first season up to the second season about this father who's in a penitentiary, and he's talking with his son, who's now the de facto head of the family, and interspersed in their conversations, dad will say, oh, there's always money in the banana stand. And the kid never understands. He never understands what dad's talking about, because he just like kind of puts it in there at random. Well, it turns out that dad had lined the family banana stand, if they sell bananas, with like $250,000 in cash, right? So there's always money in the banana stand. And you need to keep money in the banana stand. What that means is you always have to have money in trust. Now, my understanding, and you guys tell me if I'm wrong, that here in Nebraska you can have money in trust, and then you can also have a credit card on file that you can continually, you can replenish a retainer. Is that correct?
I think so.
Okay. I'm asking an ethics question here, but if anyone does that, they're probably okay. Anyway, we're gonna go over that option. But we can do that in Utah. There are some states where you can't do that. I think in West Virginia, I met a lady in West Virginia and talked to her about this. You can't do that in West Virginia. Or no, it was Ohio. You can't do it in Ohio for some reason. But wherever you can, you should do that sort of thing. So when you don't have money in trust, when your client owes you money, when it gets below $0 in trust, right, and they owe you cash, then your relationship with your client qualitatively changes from being an attorney to your client to being your client's banker. Right? Because in your retainer, you have that provision in there that says, if you owe me money, I can charge you interest on the money. I mean, ours, it's like 20% per year, compounding monthly. You know, I make it onerous if that ever happens. But, you know, that's like a bad credit card, right? And I'm just becoming their credit card dealer, their banker at that point. And that's not okay. Like, no one likes that. No one likes their banker, so don't become their banker. Always have money in trust. And the way we normally do as attorneys, right, is you pay the money for a retainer, and then you get down to $0, and then they get into the negative, and you bring it back up to 0. And then they get in the negative, and you bring it back up to 0, and it just keeps going like that. And that's when you run into this relationship problem. Because when they owe you money, they're not going to call you as much. When they do call you, they're going to be upset because they owe you money. You're going to be upset because they owe you money, right? If it's a strain on the relationship, you don't communicate as well, you're not on the same team, there's nothing good that comes from it, so don't do that. And a couple other things. One, you won't get paid if you do it this way. You're much more likely, if they owe you money, just never do it to get paid. I think that's kind of axiomatic. But the second thing is that you're also much more likely to get a bad Google review if people owe you money. So what happens is that somebody owes you $5,000 at the end of the case, and you keep going, right, and you do exceptional work for that person, you give them their kids, or whatever it is. And you get to the end, they owe you money, and you say, all right, pay up, and they don't really want to pay up. So what do? Instead, they go leave you a bad Google review. That happens much more often than when they don't owe you money, right? If they have money in trust, they're much less likely to do that. I'm not entirely sure why that is, but that seems to be a pretty consistent finding as I talk to attorneys. And one thing here, if you don't have Google reviews, or you think they're unimportant, or they're newfangled, or whatever it is, kind of get over yourself. Google reviews are the biggest thing that you need right now in order to market. The more Google reviews you have, the better you're going to be. That is the key performance indicator that you really want to look at. I mean, acquire them like that crazy lady acquires cats. You know, just get as many 5-star reviews as you possibly can. And you want to minimize the 1-star reviews, and a good way to do that is to make sure that they have money in trust. Now the question always comes up, how much money should I have in trust? This is the way I think about it. You want to have enough money in trust to cover your worst month. I mean, think about the kind of cases that you do, and when things really hit the fan, go sideways, how much time do you spend on the case in a month? And for us, as an example, our worst month is always when there's a child protective order, a regular protective order, or a temporary restraining order. Because you have to stop everything, you have to deal with that one problem. I mean, if you're the attorney in the legal team working on that, you literally have to stop everything else and deal with that problem for days and take care of it, right? And those months, you know, most of the time when that happens, that's like $7,000 to do something like that. So, you know, the best thing we could do is to get $7,000. Now, in Salt Lake and most other places that are outside Manhattan, people are not gonna give you $7,000 for a retainer on a divorce case. So you have to go down from there. And how do you go down from there? What I do is I just take, you know, when things go 95% wrong instead of 100% wrong, how much is that? Okay, because that's gonna cover almost every month that you have with almost every client. So that's what we do. And we set it at somewhere around $3,000 to $4,000. That takes care of, you know, that 95% going sideways. So that's a way to think about it, but you'll never know exactly what amount you should do until you really get in there with your data and look at how the hours work, right? And if you don't have that data and you can't just bring that up, then you need a system that allows you to do that sort of thing, right? You need a system that where you can look and say, this is how many hours I spent on this case, this is how many hours I've spent on this portion of the case, and really look through those. And you should do that pretty often to see, one, you know, what your average case take is, and then what each stage of the case is like. That allows you to price these things out and know exactly how much time you're going to spend on these cases. Okay. So that's number 4. Number 5 is if you're, yeah.
What procedure do you use when you look at your trust account and it's zero, and you don't expect the client to bring it up to the correct amount? What procedure would you use?
Yeah, we're going to talk about that right now.
All right.
Yep. No, you're good. You're good. It's a good question. So commandment number 5 is if your client doesn't pay you, stop work. Stop work right now. Stop work. Okay. This is hard for attorneys. I have a lot of friends who own law firms, and almost universally their number 1 complaint with their associates is the guy's not paying, but the associate, you know, keeps doing work on the case. And there are kind of a couple things. One reason for that is the attorney has not, that person's pay, that associate's pay, is not tied to the amount of money that associate brings in, right? So they don't actually care because they don't ever have to look at that. If you have that type of system, that's kind of a broken system, I think. There has to be an incentive. They have to know when they shouldn't work on a case, right? But if you're paying a salary and you just don't want to go to a percentage of the revenue system, then you have to have things in place. You have to have procedures in place to stop the work. We're going to talk about that in a second. But you have to have really clear triggers to make that happen. And this is the way we do it. So you guys can do it whichever way you want. But what we do is we bill within the first 5 days of the month. In fact, on the first of the month, I wake up at 4 or 5 o'clock in the morning and I do all the billing, and I get all the billing done by the time I walk in the office at 8:30 or 9. So it's all finished. Then on the 20th and those invoices go out. Then on the 20th of the month, we run credit cards to get the retainer back up to where it should be. And we're going to talk about that type of retainer in a second. But we run that on the 20th. So let's say somebody owes $1,000 to get their retainer back up and their credit card declines. Then we have a procedure for that. The procedure is the paralegal, the office manager who's doing the collections, notes that, sends out an email right then, before she does anything else, to the client, says, hey, you know, it's a template email, hey, your payment was declined, please give me credit card information that I can bill to get you back up to the requisite retainer amount, and we have to stop work on your case until that happens. Okay. Then she sends not an email, but we use Slack as an internal communication tool. So she sends a Slack to the attorney and says, hey, so-and-so was declined, so stop work on the case. Okay. So everybody knows to stop work. And I also get that Slack as well, so I see it. And then the paralegal follows up with the individual who's declined. And what we found is when that happens, 50% of the time it's because they got a new credit card, and all they have to do is call in the new credit card number, and we send them a new credit card authorization, and it fixes the problem. And that happens within about 24 hours. The other portion, they go find the money, and they pay within about 48 hours. So 24 to 48 hours is kind of what you're looking at. If they go beyond that, there are ways to deal with it, but you haven't stopped work for very long. It's 24 to 48 hours. And somehow people find money. They all say they don't have it, they can't do it, and then they find it and they continue with the case, right? But if you don't have clear guidelines that way, then people don't find money and they never find money because you don't force them to actually find the money. So that's just kind of the way it works.
Now,
Yeah.
so if you've already got a case filed in court
Mhm.
and the judge expects you to keep working on the case, how can you ethically tell your client that you're going to stop working on the case if the judge hasn't let you out?
Yeah. Now, this may be a difference between Utah and Nebraska, although I've talked to lots of attorneys and I don't think there's too much of a difference. You have an ethical obligation to help your client. You also have an ethical obligation to get paid. So if it's a point in the case where you can stop work, which is almost always, then you can stop work. If you have a hearing on Tuesday, this happens on Monday, and you have a hearing on Tuesday or Wednesday, you're in it, right? You have to do it, and that's what you do. But the way to deal with that is to make sure that you have money in the trust that covers that type of contingency, right? So again, you're not really stopping work for very long. 24 to 48 hours is usually the max. And you can almost always stop work for that amount of time. The other thing that I've really noticed is lawyers, bless our souls, we tend to go from crisis to crisis, right? You go from one crisis, like it's emergency scan modality, that's how we live our lives, we just go from crisis to crisis. And when you get paid more, you can do less, so you don't have to take on as many cases. And you don't have to go from crisis to crisis. You can plan your cases a little bit better. You can plan your day a little bit better. And when you do it like that, then you know when you can stop, right? You just plan the cases out better. You have a system for it, and you can stop if somebody doesn't pay. That's not a perfect answer, but that's a pretty good one. It's worked for us pretty well. Okay. As a safeguard for this, tell your clients how this is going to work. Tell them at the beginning when they hire you, look, we're going to do exceptional work for you. You're going to pay us. This is how you're going to pay us. If you don't pay us, we're going to stop work on the case. If you don't pay us this a certain amount of time, we're going to have to drop it. Okay. So just tell them up front, and that really solves a lot of problems. One thing you might also think about, this is one of the best things I've done in the last couple of years, is when I have new client consultations, I actually audio record the consultations. So, and I do it because I don't work the day-to-day on cases anymore, so the audio goes to the legal team, goes to the attorney and the legal team, so they know exactly what was said during the consult. So we don't ever have misinterpretations of notes or anything like that. But the other thing is, when a client comes back and says, you told me X, and you can say, I didn't tell you X, let's listen to the recording, right? Like, you have these things on tape, it solves a tremendous amount of problems. So think through that. It's a little tangential, but think through that. That's been a great thing for us. Okay, when you think about collections and a system for collections, you have to set up a system. You have to set up these triggers. You got to do this stuff if you want to get paid 100%. Don't make an attorney the head of the system, all right? Do not put an attorney in charge of collections because we're terrible at it. We're just so bad, right? We don't want to do this stuff. We want to be attorneys, and we want to do these, we want to do everything other than collect the money. So hire somebody to collect the money. And if you're on your own, or you're a true solo and you're thinking about hiring somebody, the first person you should hire in any law firm is the person to get the money, the person to do collections. Hire that person before you hire somebody to answer the phones. And answering the phones, so terrible answering the phones as an attorney. But as much as I disdain that, right, hire somebody to do the collections first and to run that system. Like, that's it. And never, ever, ever put a lawyer in charge of it. And if you're, I made this presentation to some law students earlier today. I told them, look, if your bosses put you in charge of collecting from your clients, and you work for a law firm and they make you do that, go find another law firm. Like, go get another job at a law firm, because that law firm's not gonna be around a ton, you know, for a really long time, because their collection rate's not gonna be that good, and it just sucks to collect from your clients. Okay. All right, commandment number 6 is specialize. Now, I'm talking to a group of lawyers here in Lincoln, Nebraska. It's a relatively large city. You can all specialize. Okay, this is not Broken Bow, or you know, the Utah equivalent would be like Brigham City or something, right? Like, these are small towns. In small towns, you have to generalize a little bit, but here you don't have to. You can specialize. And what I mean by specialize is do one thing. And that's it. Don't do 2 things, do one thing, and do it exceptionally well. The benefits are numerous. One, you're gonna know exactly what to do in almost every situation that you encounter, right? It'll actually get boring after a while to do one thing because you're so good at it and you're so knowledgeable about it, okay? But that also means that you're not waking up at 3 o'clock in the morning with your heart pounding. Did I miss something? Why am I doing this? You don't have that sort of thing. Your stress tends to go away. And the second thing is, specialists get paid more. They get paid a lot more. So we know this, we don't believe this as attorneys. For some reason, we think that generalists make more money as attorneys than specialists. This is not true. You know, general practice firms can make money, but specialists make more money doing what they do. And we know this to be true because we can look at doctors. The average family care doc will make about $150,000 a year in America. Not bad, right? Not great, not bad. Then a general surgeon will make probably on the order of $300,000 to $400,000 a year, $500,000 a year. It's a lot better. That's a mid-range specialist, right? A general surgeon. A brain surgeon will make $1 million a year. Okay, and he'll actually do less stuff. He does less stuff, but it's much more intensive on that one thing, and that person will get paid buku bucks because they specialize. Okay, it's just the way it is in practically every occupation out there, and we're no different. So specialize in that one thing. And if you can't, if you're in a rural area and you can't do that, then specialize in as few things as you possibly can. Right? 2 things, maybe 3 things. I don't think I've ever met an attorney, though, that got past 3 things and really knew what they were doing. It was always scrambling to kind of figure out something. I mean, if you're doing divorce and PI and water rights cases and suing your county for some such thing, like, you're not really good at much of anything you do. So don't do that. Just specialize. Number 7. This is kind of where the rubber meets the road. Fire your worst client today. I see heads nodding. I see people cocking their head with their eyes kind of up like this, like they're imagining a face. Everybody saw a face when I said that, right? Okay. That's the person you fire. Because your brain knows, I hate that guy. I really, really hate that guy. My paralegal hates him. The people in the office hate him. Mean to people, he doesn't pay his bill. That guy. That first came up, fire that person today. Okay. That person doesn't pay usually, and it uses all your time. Okay. So there's and the reason for this, the reason I'm telling you this, is one, it just makes your life a lot better. You don't have that person in your life anymore, and that in and of itself is worth the money. But the second thing is, this is actually an economic thing. So you have what's called the Pareto principle, which is also known as the 80-20 principle. It's an economic principle that the majority of an output comes from a minority of an input. So Pareto was an Italian economist. I believe what he was studying was land holdings in Sicily. So what he found is approximately 20% of the landed gentry, you know, the people owned about 80% of the land. And this is pretty normal stuff. It's called power law. It's called a whole bunch of things. But it holds for attorneys as well. So in any law firm, most of the time, about 80% of your revenue is going to come from 20 to 30% of your clients. Okay? And it also means that 80% of the pain in your rear end is going to come from 20% of your clients. Okay? And those two populations are never the same. Like the guy who really annoys you is almost always the guy who doesn't pay. It's not the guy who pays you the most, because they're good clients, right? Like those are A clients, and they're almost never the same population. So when you get rid of the 20% that cause you 80% of the problems and also don't pay you, you have time to then look at the 20% that pay you a lot and serve them better. And that means that you get more people like those people, because those people don't hang out with losers. Those people hang out with, other A clients, right? And you're gonna bring more of those types of people in. So you're actually gonna make more money when you fire your worst client. And this is a self-fulfilling, or this is a self-perpetuating commandment. So you fire that guy that you saw in your head, you fire that person, and then next week, your head's gonna tell you somebody else that's really an F client, like it's just a terrible client. You should fire that person too, right? And you should continue doing this until you get to clients that are either graded A or B, right? And we all kind of know intuitively who's an A client, a B client, a C client, a B and F client, right? You want to get to the point where you're just taking A or B clients. And firing the F clients gets you to that opportunity to have the A and B clients. Okay. And the other thing about this, your paralegal will absolutely love you. And whoever answers the phones will absolutely love you. Because this, that F client calls up and is just a jerk to everybody, not just you. Okay. So you're going to keep your paralegals, they're going to be happier. You're going to keep the person who answers the phones, they're going to be happier. It's just, there is no downside to this at all, right? There's no downside to it. Okay. Then number 8, make your family, and your team your first priority. And your client comes second. Okay. We're told in law and everything else that the client is always right. That's a lie. They're not always right. In fact, they're very usually wrong. You don't have to tell them that, but it's the way it is. And you were taught that we serve them and make them our priority as a law firm. We don't at all. Okay. Make yourself, your team, and your family your top priorities. Because when you make your client your top priority, you don't fire that F client. You don't get paid 100% for what you do. You do tons of work that you would never otherwise do. Your team hates it because they're not getting paid what they should. Again, because you're not getting paid what you should, so it can't trickle down. You can't pay them more. You're not taking vacations like you should because you're working all the time. You're stressed out of your mind. These are the things that come from putting your clients first and putting yourself and your team second. And that's not sustainable. We do this as attorneys, and this in large part is why we burn out as attorneys. It's why we drink a lot, and it's why we get divorced a lot. So don't be doing this stuff, right? Live a better life than that. Just tell yourself, all right, I'm done. I'm not doing this anymore. When you put yourself first and your team and your family first, you're going to go on vacation. You're going to do those things that you like. You're going to serve the people you like. You're not going to serve those people you don't. You're going to do better work as an attorney because you actually like being an attorney. You get paid a lot for being an attorney, which makes you want to be a better attorney. It's a flywheel, and it's an upward flywheel. So make yourself, your family, and your team your first priority, and make your clients your second priority. You'll be a much better attorney, and it'll be much more sustainable than putting your clients first. So that's the end of the 8 commandments. Any questions? We can go over those. I gave you, as part of the handout, I gave you a retainer. Now, I've not vetted this for Nebraska, although I imagine this works. And this retainer is what I call an evergreen retainer. So you set your amount, say it's $3,000 or $4,000 of retainer, and every month your clients draw on that, or you draw on that, and then you get your clients back up to $3,000 or $4,000 or $5,000, whatever it is, right? So you always have money in trust. Yeah.
I have a question, and I apologize, I missed the first couple of minutes. In your firm's practice, how many clients will provide retainers to the evergreen retainers? Because I'm just guessing if you ask this bunch to hold up their hands as to everyone who's even heard about them, it would be less than all of us. And if you asked even those of us who ought to do it, if we've ever done it, who hasn't, and I'd be one of those guys saying I've never done it.
So the question is, how often do my clients do it?
Mm-hmm.
It's 100% like that.
Seriously?
I don't serve people unless they do it evergreen.
Excellent.
Yeah. Actually, we do flat fees. If anybody has questions about that, we can certainly talk about that. But we've come up with a way to do flat fees in litigated divorces. So that's even better. You can do flat fees, just do flat fees, man. It's so much better than the billable hour. No one likes the billable hour. Clients hate it. I don't like thinking about my life in 6-minute increments either. The data is actually the.
How do you figure the flat fee schedule?
How do you figure it out? Yeah, let me address that in one
Okay,
second.
I'm sorry.
So, the data are that 85% of legal consumers want flat fees, and in my realm of divorce, 4% of divorce attorneys offer flat fees. So, you want to look different than all of the other attorneys around you in divorce and pretty much everywhere else, do flat fees, right? And you should want to look different than everybody else. Like, you shouldn't want to be the same. Ask your question again, I forgot.
Forget what the heck it was.
Oh, how do you figure out?
Oh, yeah, how do you, I mean, I assume that's trial and error and evaluating time and stuff.
That's trial and error. So everything I'm explaining here comes from the fact that I sucked at all of this in the beginning, right? I just had to kind of figure it out. So the way you do it, this is the way I did it. I would go back, again, I went back to the data and I figured out for each stage of the case. So for the initial stage of a divorce, for mediation in a divorce, for temporary orders in a divorce, and I don't know if these terms correlate at all with how you guys do things, but in Utah, that's how we do it. For each stage of the divorce, I would go back and I would figure out what the average was across a whole bunch of cases for that stage. And then I would apply a multiplier to that, because every once in a while, you're gonna have some case go really sideways, right? And instead of it being $5,000 for the stage of the case or whatever it is, it's gonna be $15,000. You have that terrible attorney you hate on the other side, and they were really intransigent with the client. So you have to apply a multiplier to kind of, bake some room in there. And then you do that, and you will invariably be wrong the first time you do it. And you will take a bath on some cases, and that will upset you. And you will not want to do flat fees again because you took a bath. And that's what most attorneys do. They try flat fees for a little bit, they take a bath on some cases, and they're like, man, I'm done, I'm not doing this anymore. But what you need to do is go back and just admit that you were wrong and increase your price. Right? Figure it out and increase your price. And eventually you're gonna find an equilibrium where it works. Okay. Now this doesn't answer the ethical question of how do you deal with flat fees. I don't know how your bar looks at flat fees, but we're smart people. You can figure out how to make flat fees work with your ethics, I guarantee you. Because I have, and lots of other people across America have done it in pretty much every jurisdiction there is. Yeah.
So what do you do with the couple, like I had last week, that comes in together when you're expecting one of them, and they do the complaint, voluntary appearance, settlement agreement, parenting plan, everything in 2 hours, and the case is done, and you thought, it was gonna take longer, and if you give the money back, if you've asked them for a flat fee and they have it done in 4 hours for the whole thing?
Yeah, so I can answer this. In Utah, there's a rule that you can't make too much money on a case, right?
Right.
Which is ridiculous. I think that's a stupid ethical rule, but whatever. Because they don't care if you do way too much work on a case, if you take a flat fee and you have to do 10 times the amount of work you think and you get paid $40 an hour for it, the bar doesn't give a crap about that, but they certainly care if you do a case and you get paid $700 an hour for it, because it just ends early. So anyway, if it's unethical to keep all of the money, then don't keep all the money. Just give them back some money and make it ethical within whatever ethics of the jurisdiction that you're in. That's fine. Just work it, work it with your team, figure that out, and give them a refund. But if it's not unethical, take the money. Anybody else have?
So, just I don't know, this is half question, half comment. I'm an immigration attorney, and every other immigration attorney I know does flat fees.
Yep.
Because the majority of, if not all of the clients that we serve don't have thousands of dollars to put in up front, and they don't have the patience or maybe the funds to keep bringing in money every month.
Sure.
To pay for an hourly rate. So
Yeah.
I have this weird, crazy hybrid system where I take maybe a $1,500 or a couple $1,000s in the first month, and then I take monthly payments to make up a minimum fee,
Mhm.
and then if it's unnecessarily complicated. But I feel like it pays for my time more accurately. And inevitably, I always end up going over my initial estimate of hours, always, every single time.
Yep.
I've been practicing for 15 years and I've never been able to figure out how much time a given case is going to be able to take. But I'm really afraid to do a flat fee because I feel like if I do a flat fee, I'm going to end up working more than my estimate and I'm not going to get paid for the work I do. So I'm going to be taking a bath on every single case.
Yep. Yep.
So I don't know what my question is, but I guess my question
Maybe
is,
not take a bath.
baths are good for you, they keep you clean. But I guess my question is, your presentation seems to be based on the billable hours, so you seem to
It
have
is.
thought a lot about billable hours. So even though you don't seem to like billable hours, do you still think that you can get paid doing billable hours and the clients will pay you and they'll be happy with you?
Yeah, so I do this, and you're exactly right. I do this on the billable hour because, again, like 95, 96% of attorneys do billable hour, right? I do flat fees, so I thought a lot about both of them. This is the way, these things right here are the way that I collect 98% on our billable hour cases. I still have some billable hour cases, because somebody comes in, invariably 10% of cases come in, and you're like, I don't know exactly how I'm supposed to deal with that. And if you don't know exactly how to deal with it, then the flat fee doesn't really work. So, you know, these are set up. We collect at a very high rate on billable hour. On what you're talking about, it always goes above and beyond what you think, but what you're thinking isn't really comporting to the data that you're using. I guarantee if you went back and aggregated your data on these cases, you'd figure out kind of where that is, the actual numbers for these things. But when you go and do that, then just apply a multiplier to it, right? Or from where you are right now, whatever you think that is, just times it by 2, and then see how that works. And if it doesn't work, if you make too much money, it's a good problem to have, and you can always drop it. And if it doesn't make enough money, then multiply it by 2.5 and see where you are.
But then my concern is I'm going to tell my clients, okay, here's your flat fee, and they're going to say, well, that's too much. I'm just going to go to this other guy down the street who's going to charge me half as much or a third as much.
Yep.
You know, so.
So that's a sales problem, right? And that's kind of a different presentation, but really that's a sales problem in the sense that you have not communicated. I'm being a little harsh on you, but you have not communicated the worth of what you do well enough to that client to compel them to hire you, okay? And that's a problem that we all have as attorneys. We suck at sales because we don't ever get taught how to sell stuff, right? And if you want some books I'm a reader and I have to read things in order to get any of it. So there's some books that can help with that, but that's really what that problem is. Like, you need to hone your pitch and hone it to a point that they will not want to go to that guy down the street, even though he costs less, because you have such value and you communicate such value to those people and to their families that they will want to pay you. Like that's where that problem lies.
Mm.
Yeah.
Would you name one sales book you like?
Yeah, so 2 of them that I always tell people to get, Sell or Survive. I think that's Sell or Survive by Grant Cardone. And then The Closer's Survival Guide. Again, by Grant Cardone.
Thank you.
Those are the 2 best. The Closer's Survival Guide is the best book on sales you'll ever read. So selling is a process. It involves the relationship and getting people through the payment portion of it. And then even after that, you've got to keep selling your client on the value you bring them. But closing is a subset of selling, and that's that portion where you tell people, all right, how are you going to pay me, right? And you get them to pay you. And then they tell you, there's a guy down the street that charges half as much. Why should I pay them? That's the close, right? And you have to have specific ways to deal with each of those objections or stalls or whatever it is that you encounter. And that's what the Closer Survival Guide does, is it gives you kind of a how-to on it. It's great.
Do you feel like giving them kind of your worst case scenario of here's what could happen if you don't have an attorney, and here's how I can help you alleviate the risks is a good part of that?
Yeah, fear is great. Fear is like salt in food.
Yeah.
If you don't have salt, food doesn't taste good. You put too much in there and it just tastes awful, right? You have to have the right amount of it.
So I'll let them fear a little bit what's gonna happen in the temporary hearing before I reassure them, just so they can realize their value sometimes.
fear's okay. It's a great way to sell, right? You don't want to be a fear monger, but people need to know, if you don't go with me, I mean, this is what I do for you, and this is how I serve you exceptionally well. And if you don't go with me, then, you know, these things can happen. Right? There's nothing wrong with that. That's great. You just have to serve them exceptionally well. Don't lie to them. Just serve them. Yeah. Any other questions? Okay. Thanks, guys. I really appreciate the opportunity.